Hello, my name is Shawn Andrews, your host for Andrew Legal Matters. Today I will be speaking with Barry Kaplan of Kaplan Intellectual Property Law, and we will be discussing the world of intellectual property law. To give you some background on Attorney Kaplan, Barry represents and counsels clients in all areas of intellectual property and computer law. Prior to attending law school at Georgia State University, Barry was a mechanical engineer for Atlanta-based Scientific Atlanta Inc.'s Electro Products Division, where he served as one of the lead product engineers. Barry has an amazing family, his wife Susie and their boys Ryan and Jonathan. Barry loves music, computers, ethnic foods of all kinds, tennis, and the outdoors. Welcome, Barry, to Andrew Legal Matters.
Thanks, Shawn. That was a great introduction, and congrats to you for putting together such an exciting lineup of IP-related podcasts.
You are very welcome. Thank you. So, Barry, tell us what inspired you to become an intellectual property attorney.
Well, my journey, I guess, started back in college as a senior mechanical engineering student. At the outset of our senior design project, our professor sent us out to do some research on our proposed designs. And, of course, part of that research was looking at patents to be sure we weren't reinventing the proverbial wheel. I admit I was immediately bitten by the patent bug. After graduation, I went to work as an engineer, as you mentioned. I was working on cutting-edge hardware for military, government, telecom infrastructure projects. And I realized that there were exciting things happening at the junction of engineering, law, government, business, and I wanted to be part of that. So when the company had a downturn, I took the opportunity, went back to law school to become an IP attorney, and most specifically to use my engineering background to become a registered patent attorney. From there, my path was through the Georgia Bar exam, the Patent Office's registration exam, lots of court admissions, and now through a 25-plus year IP career.
Very interesting. So why do you think intellectual property is trending today?
There are so many reasons, but I think most importantly, IP sits at the very core of almost every business, from startups to the largest companies, as well as being at the core of our research universities, incubators, scientific agencies, even the military. IP strategy, management, and enforcement give companies and other IP owners room to navigate in their market space, to protect themselves from some of their competitive pressures that they face in that marketplace, to build an important asset base, increase their valuation, to attract capital investment, to employ people, and ultimately, I guess, to return value to shareholders, the economy, and to the public. I think it's worth recognizing that IP covers not only inventions and patents, but also things like branding, trade dress and product configurations, copyrights for creative properties like music, books, movie software, trade secrets, know-how, licensing, development, research agreements, franchise agreements for restaurants, and so forth. And we also recognize that IP touches not only the proprietary side of commerce, but also non-proprietary technologies and creative content like open source and Creative Commons properties. Each of these things touches almost every business, regardless of size, our universities, scientific, military communities, and our active economy needs an IP community and the focus on it to grow, thrive, employ people with rewarding, challenging opportunities so that our economy grows.
I think you made some very good points in that description of what you just described to us. And when you say open source, specifically, what do you mean by that?
Well, so I think open source is best recognized in terms of software. Historically, we have proprietary models where you enter a licensing agreement to use the software, and it's kept confidential, secret. Only the company behind it knows what's in the code, and only that company and its engineers and software designers can make changes to that. Open source software is exactly the opposite. It uses copyright law to promote openness in that code and ensure that the code is widely distributed, can be looked at by millions of eyes all over the world, and then can form the basis of a free environment for computer for whether it's for operating systems, software, cloud-based technologies, and the like. And, of course, that movement has now moved into hardware. We look at 3D printing types of technologies and open hardware development activities that are happening in the engineering communities. And so we see that movement growing, I think, day by day. And maybe I'll address that topic again in a little while.
I think that makes a very good point. What you just said, technology definitely seems to be evolving in every practice group. So I definitely think that's key. So tell me, what do you think intellectual property, or what are the business strategies that you think are different today than it was years ago?
Wow, that's a good question. IP law, I think, has gotten very complex and complicated over just the years of my practice, which is, even though it's long, is relatively short in terms of the IP history of the United States. The U.S. has entered into several international treaties, each of which has had a decided and significant impact on historic U.S. law and precedent. And most recently, we have the introduction of the America Invents Act that moved the U.S. from a first-to-invent system to a first-to-file system. As well, the AIA implemented inter-party review and covered business method review procedures that have shifted IP litigation strategy in sweeping ways. The U.S. Supreme Court is weighing in more heavily on IP cases than ever before in history, which, of course, opens opportunities for some business models with negative impact on others. So with the advent and growth of our electronic and digital economy, IP rights are constantly in flux these days, along with an ever-changing legal landscape, and so IP strategy is taking center stage and is becoming more sophisticated and, I think, more important every year.
Yes. So tell me, what does a typical day entail for you as an intellectual property attorney?
Well, busyness. One of the things I love about being an IP attorney, and especially being a registered patent attorney, is that my work day is just never the same. Days are always challenging. Some days I might be working with a client to map out or refine an IP strategy for a new product or business. Other days I might be writing or prosecuting a patent or trademark application, or I could be writing or negotiating an IP licensing agreement, or working on an infringement allegation on behalf of a client. Some days working on litigation briefs or heading out to court appearances. And of course, it's worth mentioning that being an attorney also means being a business person. So we also have that side of the practice to manage and care for.
Now, for those that don't know, what does it exactly mean to be a registered patent attorney as opposed to just a patent attorney that's not registered?
Well, in order to practice and represent clients before the patent office. This is not true on the trademark side of things, where just being an attorney, a barred attorney, is sufficient. But on the patent side of things, they require anybody who represents clients in front of that agency to be registered. And in order to be registered, one has to have a technical degree or qualification in a certain number of enumerated scientific or medical subjects. You have to take a registration exam proving competency, and then, of course, to be a registered attorney, you have to have passed the bar exam of your home state to carry that title. So the other part of your question, one can be a patent attorney not having passed the registration exam, but one would then work under the auspices of a registered patent attorney, and that registered patent attorney would take responsibility for those cases going through the patent office.
Okay, that makes sense. And I guess for you, in your position as an IP attorney, what would you say is the most challenging part of your job?
I think the diversity and breadth of a specialty IP practice is challenging, because it requires staying current not only on the latest law, which of course is no small challenge by itself, but also on the latest technology trends, marketing trends, consumer preferences, social media developments, and so on. I find that I have to stay in sync not only with my clients, but also sometimes be ahead of them as to what's happening in the marketplace, so that I can be an active advisor and help them navigate through an increasingly competitive and changing space that they may or may not be see coming. And then, of course, balancing each client's needs and our workflow to try to provide incredible service and value day after day, year after year. It's all challenging, but fun.
I can definitely see that and hear that in your voice. Mm-hmm. So where do you see intellectual property headed in the near future?
That's a crystal ball kind of question, isn't it? There are a lot of legal and business challenges happening every day that of course make it hard to predict. But I'll try to put on my prognostication hat here. I think in the immediate future, at least on the patent side, we've got the oil states case, is being briefed as we speak for argument at the U.S. Supreme Court. This is probably one of the most important cases of this generation. It's going to go to the very heart of the patent system, how we enforce and defend patents, how the patent system itself will operate going forward. The Supreme Court decision is going to have a marked impact on nearly every patent holder in the U.S. and will affect private IP strategy and public policy, I think, for years going forward. On the trademark side of things, the U.S. Supreme Court just ruled in the Tam case that the First Amendment trumps the Trademark Act's long-held and historically based prohibition against registering a mark that's disparaging or offensive. We're already seeing registrations in this area that will test the boundaries of that ruling, and which I think will engender a lot of public debate about what is the appropriate scope of business speech under the First Amendment and the continued interplay with the trademark laws. On the copyright side of things, and as I mentioned before briefly, I think we're going to continue to see significant changes in digital licensing arrangements between copyright content owners, providers, distributors, and the like. I think it's going to continue to draw public interest in discussions surrounding net neutrality, prices consumers pay for wireless and cable services, Netflix, Spotify, YouTube subscription content, those kinds of things as well. I think we'll continue to see a shift in technology space as applied to the software and hardware, like we discussed earlier, moving from historically proprietary models towards open source and copyleft licensing schemas. As I mentioned, I think we're already seeing that pressure occurring in the market, fueled by open source operating systems, 3D printing technologies, the need to integrate and maintain legacy software systems and controls beyond the day-to-day operational means of many of our companies. So I think the current trend of moving towards open source, web-managed infrastructure, business and distribution models will only accelerate. And of course, that's on the copyright and branding and trade secret kind of discussion space.
Makes sense. Got it. So, Barry, what is the best way for people to get in contact with you?
Well, I would love it if they would head over to kaplanip.com. That's KAPLANIP.com and navigate to the contact page. As well, my contact information is in the header of each of the pages on my website.
Okay, wonderful. Well, thank you, Barry, for being a guest on Andrew Legal Matters.
It's been my pleasure, Shawn. Thanks so much for having me.
You're very welcome, and thank you for another episode of Legal Matters.